Officer Dave, would you open the courtroom for us?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, counsel.
Good morning, Your Honor. How are you doing?
I'm good. How are you today?
Good, good. Y'all living the dream.
What file do you have today?
I have two. I'm here for Michigan First Credit Union. It is my defendants' last names are Kimbrough and Reed.
Okay, let me see. Kimbrough and Reed. Okay, I'll put you back in the waiting room.
Thank you, Your Honor.
Cadwell and Frost. I saw Frost a minute ago. Three. Counsel?
Yes, good morning, Your Honor.
We're waiting for her to connect. All right, we are on the record. This is file number 18142-023, Johnson Financial Group versus India Cadwell. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Robert Goodman, P55670, appearing on behalf of the plaintiff.
And what is your name, ma'am?
Good morning, Your Honor. My name is India Cadwell.
You are the moving party. What is the basis of your objection to garnishment?
Okay, well, I received further information from Goodman and Frost since I filed. Apparently they've been looking for me since 18, but when I called, the paperwork came in through my employer and I called Goodman and Frost, they said the bill was from 1999 through 2012. I wasn't even at that address in 2012. I hadn't been at that address since 2007.
Do you have any other basis for your objection to garnishment?
And also at this point, I am currently dealing with another garnishment through Winter and Frost, or yeah, not Winter and Frost, but Winter and something. I do have the case number, but at the time that I filed the paperwork, I didn't have the case number or the phone number, so I wasn't able to put it on the paperwork. But right now, I'm currently dealing with another garnishment at this time.
Mr. Goodman, your response.
Thank you, Your Honor. We filed a response in that and indicated to the court that we don't feel that this is a valid objection because the defendant is attempting to attack the underlying judgment, which is improper pursuant to MCR 3101 K1, which specifically says you cannot attack the underlying judgment. I also wanted to indicate to the court that after the defendant was served, she contacted our office, spoke to one of my customer service representatives on March 12th, and at that time agreed to a consent judgment and a payment plan of $100 a month. We sent her out paperwork and she never returned it. So for those reasons, I would indicate to the court that we feel that the objection should be denied.
All right. Ma'am, is there anything else you want to tell the court?
I'm not familiar with no paperwork that was done back in March, but I've been dealing with another garnishment for a couple years now. So I don't see why I would agree to another payment plan when I'm already dealing with a payment plan.
All right, the court's prepared to rule. Thank you both. Ma'am, the file indicates in this matter that you were personally served back in February 2018. Judgment by default entered April 10th, 2018. You may not use the objection to garnishment as a method of attacking the underlying judgment. In regard to the fact that you are already being garnished, the employer will not take out more than is permitted by law, even though there are 2 garnishments going forward. Having failed to state a valid objection to garnishment, that objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Hello?
Ma'am?
Yes. Well, is there any way I can get on the payment plan with this one?
Ma'am, if you file a motion for installment payments, pay the motion fee, serve the other side, the court will consider it. But it's not before me today, ma'am. Thank you for coming in. We're off the record. Anything else, Mr. Goodman? Is that your only one?
That's my only one. Thank you, Your Honor.
Thanks for coming in. We're off the record. Good morning.
Good morning.
We are on the record calling file number 21-152-075, Michigan First Credit Union versus Felicia Reed. Date and time for objection to garnishment. Your appearances.
Your Honor, Michael T. Mamet, P81102 on behalf of plaintiff.
And what is your name, ma'am?
My name is Felicia Reed.
You are the moving party. What is the basis of your objection to garnishment?
Yes, I would like to explain my circumstances. I did try to reach out to the company to let them know that I was having surgery and I was going to be off of work for a period of time with no pay. And I did give that information to them. And then I got notices saying that they're going to stop the installments because I missed payments. But I did not get any pay while I was off. I had FMLA that covered my job, but I didn't have any sick time built up to cover me while I was off. So I didn't get any payment. I was off for 3.5 months. And I did try to report that prior to going off on surgery. So now that I'm back to work, I would like to have the opportunity to begin payments again and move forward with the installments, and please not have my wages garnished or my potential income taxes, because I'm trying to get back on track with not only them, but everybody else that I'm behind with.
Your response.
Good morning, Your Honor. Your Honor, the inability to pay is not a defense. The installment order was set aside September 8th, 2022. And even if there was an installment payment order in plan, her objection would still be invalid because it's based on a tax garnishment. And the presence of any installment order doesn't prevent the tax garnishment to begin with.
All right. The court's prepared.
Didn't know that.
First of all, ma'am, your objection, because you are attempting to claim protection from income tax garnishment, is invalid. Even if you had an installment payment order and you do not. This matter was resolved by a consent judgment that was entered back on December 1st, 2021.
Correct.
Thereafter, you failed to make the payments and the consent judgment provision was set aside. In any event, even if you had the installment payment order, the objection to garnishment is not valid because it would be a garnishment only. You're speaking now of a garnishment of an income tax from the Michigan Department of Treasury, which is not protected by any installment payment order. So your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court.
Okay.
Now, you also filed
Mhm.
request for installment payments. What are you asking?
So I am asking, okay, can I get a clarification just for a second? So the garnishment would take place regardless to the installment payment for any income taxes. But for my
Yes.
wages, okay, for my ongoing wages, would that be garnished as well, is what you're saying?
No, what I'm saying
Okay.
is that the matter you brought before me, which is the
Mhm.
only thing I'm deciding, is the
Mhm.
objection to garnishment is denied. Now, the second question, you ever
Mhm.
asked for an installment payment? I'm asking
Yeah.
you what you are asking for.
Okay, I was asking to have the installment payment reinstated, if I could. No, I was paying $50 bi-weekly. I'm asking if I can pay $50 per month because I'm so far behind with everybody and I'm trying to get caught up. So I am asking, yes,
So you want to pay less than the terms of the consent order, is that correct?
that is correct. And the only reason for that is because I'm trying to get, I'm drowning right now financially.
All right, let me hear from counsel.
Good morning, Your Honor. Once again, as of this morning, there's $17,364.16 owing on this, and it's still collecting interest. At $50 a month at 13%, she's not even going to come close to even working any portion of this down. And secondly, I haven't received a motion for an installment order. So I would ask that one, if the defendant does plan on filing one, she can go ahead and do that, but provide financial information to our office so we get a better understanding of her actual situation instead of just taking her word for it.
Wow. Okay.
Here's the
I
situation.
have no reason to lie.
Excuse me.
I have no reason to lie.
Excuse me, ma'am.
Mm-hmm.
Please don't interrupt me.
I'm sorry. I don't mean to. I apologize.
All right, the court is going to deny your request for installment payments as requested. The consent order that the parties had agreed to provided for $100 in essence a week, a month, twice bi-weekly. You're asking for less than that. That's not what the parties agreed to. If you want to file a motion for installment payments, serve the other side, provide the information that's required as part of that, I'll consider it. But I will not consider a request for a less than what you had agreed to back in December of 2021 when the said judgment was entered. In regard to my decisions, you have an absolute right to appeal my decisions. That appeal will be perfected within 21 days today in the Wayne County Circuit Court. Court will send you out 2 orders. There'll be an order denying the objection to garnishment. There'll be an order denying your request for installment payments. Thank you both for coming in.
Can I make another statement, sir?
Ma'am?
May I make another statement?
Go ahead.
The only reason why I asked for the decrease is because situations has changed financially for me since December. That's the only reason why I asked for that, sir.
Thank you, ma'am. We're off the record.
Thank you, Your Honor.
I'll put you back in the waiting room. You have one more, as I understand it.
Yes, Your Honor. Miss Kimbrough, I believe.
I don't see that name as of yet.
Thank you.
Morning, counsel.
Good morning, Your Honor.
What file do you have today?
I am here on the Capital Alliance Financial, Jesse Hawkins.
I believe I have Mr. Hawkins. Let's get started.
Okay.
I don't have Mr. Hawkins. I have him visual, but I do not have audio. Let's see if we can get him back here. If not, I'll put you back in the waiting room and we'll try another file.
Totally understand.
I think what's happening with a lot of these people is that when they're coming on and their phone asks them if they want to use a computer audio, they're saying no. And then they can't get back.
Exactly right.
So they do a better job of explaining to folks how to use this, it would be helpful, but you know how that is. Not likely to occur.
I don't think so. In a perfect world, yes.
Yes. Still better though, I would assume, for you than driving from district court to district court on Wednesdays.
We would be probably having local counsel attend most of these. I mean, our main office, I'm here in Grand Rapids, Michigan, so I wouldn't be attending any of these. So,
Let's say, yeah, he's collecting the audio this time.
okay.
Now, assuming he can make the connection, we can start. He's connecting though. At least that's forward progress. We're not making any progress here. I have to put you back in the waiting room, try another case.
Okay.
Can't keep waiting all this time. Hello,
Hello,
what is your name?
my name is Jesse Hawkins.
Jesse Hawkins?
Yes,
Okay. Okay, well, let's do it that way. I guess we'll have to move on. All right, we are on the record calling file 10110-454, Capital Alliance Finance versus Jesse Hawkins. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of Plaintiff Capital Alliance Financial.
What is your name, sir?
My name is Jesse Hawkins.
Mr. Hawkins, you are the moving party. What is the basis of your objection to garnishment?
My objection is I was never notified of this debt. I was never given the opportunity to take care of this debt. They have been billing. They've been sending all this information to us, so I'll have no idea where the address comes from. So I just had never had the opportunity. This is the first I heard of this on the 7th of October. I received a letter of garnishment. Never given the opportunity to pay this debt, and never had a chance to. So I had no idea what was going on. All I just got was this last garnishment notification, with never opportunity to handle it myself before garnishment.
Counsel, your response.
Your Honor, this is a default judgment back in 2010, and the judgment was renewed in August of 2020. I lost track of how many different garnishments we filed on in this case. The garnishment that he lists on his objection to garnishment is one we actually filed last year in October. It was a state income tax garnishment. We filed an employer garnishment earlier this year, so I'm not for sure which one he's attacking. He listed the state tax garn. He also listed a prior bankruptcy, which was dismissed. So I'm not for sure on what basis he's saying he was never notified of this debt. And my other contention would be that an objection to garnishment is not the proper method to attack the underlying judgment. So I would find on the basis of all these that there's no valid objection to the garn in this matter, and I ask that the court find so.
Mr. Hawkins? Anything else?
Yes,
you
sir.
want to say?
Their address listed on these garnishments all is incorrect. So the gentleman saying I've been served all these, they never sent anything to my address. Yet the original, I have been lived at this address since 2004. I never moved, never had any, so then they sent in all these notices to somewhere down in Detroit or Highland Park, Michigan, so all these garnishments, I have never received anything from my employer. My employer has nothing but this last garnishment of my taxes. I contacted my employer to say, I'm being levied a garnishment against my check. I've been working for the same state of Michigan since 2008. They have nothing on file saying that a levy. So I had no idea none of this stuff was being processed. So I feel as though the attorney, whoever they've been sending this stuff to, it has not been me. The only notice I have ever received was the taxes being withheld, a third-party tax withheld on this is October 7th, 2022. So I understand I did was filing bankruptcy. Fortunately for me, I ended up getting my finances together, and I did not have to proceed with the bankruptcy. And I've been trying to clean up my credit and doing all the proper things. So if I had opportunity to pay this debt, I definitely would like to take advantage of that. But I don't feel as though I was very given an opportunity to, because I have never received any of this documentation. I went to the court and requested that the court give me every case, everything that was been filed with you guys, and all of these notices has been sent to Detroit somewhere, and I don't know where they get this address from. The address on file with my credit card company, that the original debt is all the same address. So I don't know where the attorneys who's serving these papers, who's following this situation, where they get this address from. I've been lived at the same address for almost 20 some years. So they just, I feel as though, and then I have on this judgment, it says that I owe $30,000, $30,900 and some dollars. When in fact the court's judgment only says it's $12,000. So it's just, I feel as this is some fraud going on here, and that's why I'm going to know to the judge that because this garnishment says I owe $30,900. I never had a credit card, and that I never had that much credit in my life, so I have no idea what these amounts coming from. But the court action paper said different amounts.
All right.
So it's very confusing. I never had my objection is there is no need to garnish because I'm willing to take care of my bills. I just never had the opportunity to with this situation right here.
All right. The court's prepared to rule. Two things that you need to understand. Under Michigan Court Rule 3.101K, you may not use the objection to garnishment as a means of attacking the underlying judgment. That's number one. You cannot say my objection to garnishment is there's something wrong with the judgment. Secondly, this is a judgment that was entered by default back in October of 2010 and was renewed for another 10 years back in August of 2020. Judgments like credit cards bear interest. The judgment was entered back in October of 2010 in the amount of $12,769.97. So that amount of money we've been earning interest for now more than 12 years. Finally, in regard to how you get notice of a garnishment, the garnishment is served not on you. The garnishment is served on the party or the institution that the judgment creditor, the plaintiff, believes has money that belongs to you. That person or that entity is called the garnishee defendant. It is their obligation to say, yes, I have money that belongs to Mr. Hawkins, or no, I do not. It is also the obligation of the garnishee defendant to notify you that you have been garnished. Having failed to state a valid objection to garnishment, your objection to garnishment will be denied. Sir, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. I'll send out the orders denying the objections to garnishment today. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Hello? Hello?
Hello,
What is your name?
my name is Cecilia Williams.
Hang on for just a second. I have you on the side. Mr. Bach?
Yes, good morning. How are you?
Good. We are on the record. This is 201628884, Cherry Street Financial versus Sansaria Williams. Date and time for objection to garnishment, your appearances.
Yes, good morning, Your Honor. Ronald Bach here for Cherry Street Financial LLC.
You remember the State Bar of Michigan?
Yes, sir. P58296.
Ma'am, what is your name?
My name is Cecilia Williams.
And what is the basis, ma'am, of your objection to garnishment?
Well, I never received anything and I never got anything from Cherry Financial.
Okay. Do you have any other basis, ma'am, for your objection to garnishment?
I don't know what's going on. I never received any mail. I haven't received anything and I never really stayed on whatever they talking about. I got fraud going on right now. Somebody's using my name for things. So I've been working on that.
All right, counsel, your response.
Yes, Your Honor. As far as getting mail, we did mail a 30-day letter back in April of 2020. Defendant was personally served with a summons and complaint in October of 2020. The judgment was mailed by the court to the defendant in April of 2021. There was a garnishment filed last year. A disclosure went out earlier this year, and a second disclosure went out more recently. Those are all contacts that the defendant would have had. She would have known if we got her refund from the state, which we received back in March. It's a valid judgment. At this point, it's not a valid objection to the garnishment.
All right, thank you. The court's prepared to rule in this matter. Ma'am, in this case, the file indicates you were personally served at the same address that you used on your pleading today. That service was accomplished in October of 2020. The matter went forward to default judgment on that would be April 5th of 2021. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. One thing you need to understand, the garnishee defendant, the person who's being garnished, the plaintiff does not notify you. They notify the institution, the plant, or the state says, do you have money that belongs to this defendant? That individual, that organization is the garnishee defendant. It is the obligation of the garnishee defendant to advise you that you are being garnished. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You have an absolute right, ma'am, to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. Thank you for coming in. We are off the record.
Thank you, Judge.
Thank you, counsel.
Do you need an hour order or do you have one?
I have it here and I'll send it out today. Thank you.
Okay, thank you.
What is your, well, not yet, card. Good morning. What is your name? I can't hear you. What is your name, sir?
Can you hear me now?
Yes, I can hear you now. What is your name?
Christopher Kimbrough.
Christopher Kimbrough. That would be Mr. Malmet. Hang on. We'll get
I
started.
can barely hear you.
We are on the record. This is 17101-226, Michigan First Credit Union versus Christopher Kimbrough. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Local team P81102 on behalf of plaintiff.
And your name is, sir? What is your name, sir?
Christopher Kimbrough.
You are the moving party, Mr. Kimbrough. What is the basis of your objection to garnishment?
I never received anything regarding a garnishment. I never been summoned. Only thing I received was from my employer the week prior from me getting garnished.
Okay. Counsel, your response.
Your Honor, the defendant just admitted that he was served by the employer according to the Michigan court rules. And if he's referring to not being served with a summons, he's attempting to attack the underlying judgment, which is strictly prohibited under an objection to garnishment. All
right. Mr. Kimbrough, two things here. Let me go over what the file shows us here. You were served by substituted service, first class mail, certified mail, and posting on your door by a court officer at an address at the post office. Excuse me, don't interrupt me.
I'm sorry.
At an address where the post office said you were receiving mail. That service was accomplished back in April of 2017. A judgment entered against you by default on April 3rd, 2017. Since that time, they have attempted to garnish you on a couple of occasions, but you should understand how garnishment works. Once there's a judgment that's been entered against you, the plaintiff who has the judgment does not go to you. They go to an employer, they go to the state of Michigan for an income tax refund, they go to a bank, they go to a credit union, somewhere they believe that you have money. That person or that entity or that organization becomes what is known as the garnishee defendant. It is the obligation of the garnishee defendant to serve you and advise you that you have been garnished. Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment, which is the only matter before the court today, as a means of attacking the underlying judgment. Having failed to state a valid objection to garnishment, The court has no choice. Your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. The court will send out an order today. Thank you both for coming in. We are off the record.
Your Honor, briefly, would the court entertain a verbal motion for costs in this matter?
No, sir, I will not.
All right, thank you, Your Honor. Have a great day.
You too.
Judge,
Ms.
can you
Francis,
give,
good
could you give
morning.
me 1 second, Judge? I'm just finishing a case on the record.
I'll put you back in the waiting room.
Thank you. Thank you.
You ready?
Yes, Judge. Sorry about that.
This is file number 211738007, Galaxy International Purchasing versus David Thornton. Date and time for objection to garnishment. Matter set for 10 o'clock is after 10:37. Your appearance.
Najat Francis, P72322, on behalf of Plaintiff's Attorney of Record, Your Honor.
The defendant has failed to appear. In his written state, he writes, fraud, credit, debt was not defendant's. By way of history, the defendant filed an answer in this matter. The default was entered after the defendant failed to appear for pretrial, despite having received notice of that pretrial. Defendant has failed to appear. He's failed to state a valid objection to garnishment. His stated written reason is an attack on the underlying judgment, which is, of course, not permissible under MCR 3.101K. Having both failed to appear and failed in writing to set forth a valid objection to garnishment, the objection to garnishment will be denied. We'll send out an order to you today, counsel. Thank you for coming in.
Thank you.
Have a good day.
Thank you, Judge. I do have another one at 11. Should I just change my name before you put me back in the waiting room, or should I come back at 11?
Whichever is easier for you.
I'll just
you
log. I'll have Davenport versus 535.
Okay. I know who you are.
Okay, I don't know how to change my name on the phone.
All right.
I know
Don't
how to
worry
do
about
it on a computer.
It's all right.
Okay,
So you
thank
want me to
you.
put you back in the waiting room?
Yes, please.
Okay. We'll
Thank
get back
you.
to you after for the 11 o'clock call.
is the second note there of the Senate number 7 that he made. I wonder how many people have been there for the very first time. His speech where George VI gave that address to the nation in the World War II. And so he gave that speech, and in the background was the second movement. I was thinking about that. One of the most effective uses of classical music as good animal. You're absolutely right. 866-909-75. You'll hear some of the other great work here. You'll hear fun pieces like music from the Little Rascals. Masterworks. I don't think any classical DJ, if I may call it, yeah, you know, to pull off back to that and Beethoven, but he did it. Yeah, I mean, wow. That's pretty impressive. It's almost amazing. It's so much fun just bringing all of this music and relating the stories about the music and recalling the times of so many pieces ourselves, whether it was a Sunday morning, Saturday morning cartoons, those Mary Melodies cartoons. I think one of the reasons that they use that is a lot of this. Sure. This is going to work pretty darn well. Let's play. It's getting weak. And it doesn't sound good. 866-909. We like to discover visit old friends. Friends calling in. Who's stuff from Ann Arbor. We also heard Mr. Winston on the line. Thank you, sir. All right, 5 calls, 1 click in this hour, this 10-12 hour. Like 10 to join us to support 866-909-9725. 6 of you join us, you're all peanuts. 4 more to go now. We can do that. 15 minutes before the phone. 866-909-9725. As promised, is the Wilhelm Sabansky Bach. Each and every hour is the trio Settecento, which is another period instrument ensemble. By the big guy. Inspired us, and I know this that's that's Bach works, the Bach there could recite this. German, that Bach's books. And if someone sat down with number, it was Bach. He was writing on the way over. And catalog 866-909-975. This is for shooting way down. Thank you, Eric. CJ.org. Appreciate every call. Thanks so much. And so far, 6 calls and 2 votes this hour. So we at 80 joints, just 2 more to stay on track. We're 10 o'clock out. But that's 4 more minutes to go. So we now is the time to call. 6-909-725. Donate now to WRCJ. Good morning to Judith. Peter, I'm just really pleased the number of people that are giving. I see sometimes people. You can do some shopping. That you get this item, that item, what it seems to be going along really well. Attorney for $40 a year. Plus, I think the $60 pledge for the conclusive weapons. All 6 of them will be 60 to 40. Yeah, we'll do that at this time. Just 866-909-975. Peter, for it.
Hello,
Good morning,
what is your name?
Marnita Calvin.
Okay, I think I have Paulina Brown and I have Ms. Warfield. Let's see if we can get started.
Good morning, Your Honor.
Ms. Warfield, good morning. Good morning. What is your name, ma'am?
Good morning, Paulina Brown.
We are on the record calling file number 21240-532. Paulina Calvin versus Marnita Calvin. Date and time for last pretrial. Your appearances.
Good morning, Your Honor. Attorney Jessica Warfield, P85391, on behalf of the defendant in this matter, Marnita Calvin, who is present via Zoom.
The record should reflect that Marnita Calvin, the defendant, is physically present. Because she has counsel here, I will mute her because she will obviously be speaking through her counsel. And what is your name, ma'am?
Paulina Brown.
Marnita Calvin.
Okay, let's get everybody ready to go. Let's see. Marnita Calvin should be muted. Okay. This is, where are we on this file, people?
Well, Your Honor, I did submit a motion for partial summary disposition as to plaintiff's claims for damages. The last hearing that we had a brief discussion about how the plaintiff in this matter has failed to provide any evidence to support her money damages that she's claiming. And so, Your Honor, I did submit a motion stating that, defamation per se was done. However, according to the court rule, MCR 2.116 C10. We brought that motion for summary because under MCL 600.2911 subsection 1, a claim for defamation per se can be brought, and if no evidence was presented for damages, nominal damages can be awarded. Your Honor, throughout the process of this litigation, the plaintiff has failed to provide any evidence to support her claims for damages, $4,000. As stated in my motion, I did reach out to all that the plaintiff listed as a witness to her accounts. Only got in contact with 2. One stated that she would send me information and never did, Your Honor.
Okay, well, one problem, your motion, you're either the lawyer or you're a witness. You're not both. You can't put in motion conversations that you had with a witness. Well, that's why I have not calendared the matter. But it seems to me that the easiest thing to do is just set this matter for trial. The court entered an order closing out or dismissing, I should say, the claim for intentional infliction of emotional distress. There appears to be no question, but that there was a defamation per se. So the only issue is damages. So I'm going to give you a trial date, and plaintiff will be an opportunity to prove whatever damages she can prove. The trial date will be November 30th at 11 o'clock. Does that work? 11 o'clock. Does that work for everybody?
One moment, Your Honor.
It's a Wednesday like today. Yes, ma'am.
I'm just pulling up my calendar. One moment.
Yeah, I understand.
Your Honor, I do have another in-person hearing scheduled for 10 o'clock that day. If we could do the afternoon, that will work.
Where's your in-person?
Well,
I'm sorry.
I work afternoons, so
Okay, so
mornings is always better for me.
Fair for you, okay. Well, then that's real simple. Let me get my calendar out here. What's the day after November 30th?
the December 7th, Your Honor.
I'm sitting on another docket that day. That's my problem. Then I guess we'll go December 14th at 11 o'clock. Does that work for everybody?
Yes, Your Honor.
That work for you, ma'am?
This would be in person, correct?
No.
No, via Zoom?
Zoom. Yeah.
Okay. Just making sure, Your Honor.
I don't think, quite frankly, counsel, the Supremes have ordered us that wherever practicable, we shall use remote means. And I see in the criminal side, where you have a confrontation right, I see where you can have real, in my judgment, constitutional problems with remote proceedings in certain areas. But there is no confrontation right in civil.
Absolutely.
Rights in civil, notice, opportunity to be heard, opportunity to cross-examine whoever, and all of those are available by Zoom. So given the Supreme's directive, I quite frankly think I'm going to be on remote till I retire. That's my thinking. Okay, so November 14th at 11 o'clock will be your bench trial in this matter. Any evidence that the parties wish to have me consider, make sure I have it no later than December 1st. I'll send out a trial notice today.
Thank you, Your Honor. I do have a quick question just so it can go on the record. In regards to the affidavit that I did submit, it was and please correct me if I'm wrong, Your Honor, per your direction, I was under the impression that because I was the one who did reach out to the witness that Ms. Brown provided, that I had to provide an affidavit stating that I did so. I just want to make sure, I'm still still new to this. I just wanted to make sure what I did was correct or.
The problem is,
okay,
you cannot, you can't be both a witness and a lawyer in the same case.
Correct.
That's the problem. So November, yes, ma'am.
Can I ask something? Because Mrs. Warfield said that like it was no emotional, but I see a therapist every Monday and I have been seeing a therapist.
Ma'am, whatever damages you want to prove, you have a right to do that. But the question of intentional infliction of emotional distress is gone. That ship has sailed. The court entered the court entered an order following her motion for summary disposition, partial summary disposition, which to my recollection was unopposed.
Okay.
No, December 14th, 11 o'clock, we'll have our bench trial. Anything you want me to consider before then, make sure I have it, and the other side has it by December 1st. Thank you all for
Your Honor.
coming.
Thank you, Your Honor.
December 14th it is. All right. Ms. Francis, good morning.
Good morning again.
You've got Davenport versus Aisha Harris.
Davenport versus Kenya Fife.
Oh, Kenya Fife. Were you guys able
Is
to
there
serve?
another one?
Yep, there's another one. Were you able to serve Kenya Fife?
I just looked at the notes. It looks like we never got the subpoena back from the court. So I'm guessing not.
Okay, well then I'll just dismiss today. No need for you to spend more time here.
Okay, should we just adjourn it to try to serve her?
No, because remember the subpoena has a date on it.
Okay,
We don't just say, come on in sometime. The subpoena is for a specific time and specific date, and that specific time, specific date, drum roll please, is today.
okay. Okay, then we'll do a new one. I do have a separate question on a separate case.
Okay,
We missed the motion for summary disposition date last week. It somehow missed the calendar.
that I'm sure I discussed it.
I believe we got a notice saying that a new pretrial date was set.
Yeah,
Can we call the clerk and have the motion set for the next pretrial date, or just,
your motion's dismissed.
okay, could we refile it still? Do we still have time to?
You can refile it, but it won't be
Okay.
heard because it won't be, they won't have the 21 days to which they were entitled.
Okay, but we can refile it. Okay.
And what's
thank
the
you.
moral of the
And
story?
then, don't miss a date.
Indeed.
You said you have another Davenport case then?
Yeah,
Is
but I
that
got
also
another
a
lawyer here
Gallo?
on that one, so I think. Hang on for just a second.
Okay.
I'll put you in the waiting room. Let me see if he's here for that. 'Cause he might be here for something else. I'm not sure. Hang on. Good morning.
Stop.
Hello.
Good morning. Your Honor, my name is, I'm sorry.
Are you Seth Weissman?
No, I'm Sheila Siegel. That's,
What brings you here, counsel?
trying to change my name, Your Honor. I apologize. I'm handling this
All right,
hearing
don't worry
for
about
Marilyn Nyman Cone. Can you hear me?
I can hear you. Did you make service?
Thank you.
All right.
Marilyn Nyman Cone is the attorney. I'm handling for her because she died unexpectedly.
Did you? Oh, when did that happen?
What happened?
When did that happen? I didn't know that.
Oh, it just happened. The funeral was it was a week ago Friday.
Oh, my goodness. That's too bad.
Yeah, she was a wonderful person. So I'm handling this today and which wouldn't be an issue, but my computer was down, so was waiting to get in to change it for my husband's name. So I apologize, but
Don't
I
worry
am a
about that.
licensed attorney.
Before we go any further, were you able to make service on Aisha Harris?
I'm sorry, Your Honor.
This matter is set for a debtor's exam.
Yes, it is.
Were you able to serve Aisha Harris with the subpoena?
I do have the file that was provided to me, and we did serve her at her home on Fairfield on September 17th.
Okay, I don't have that proof in my
10:06
file
a.m.
yet. Okay, so what I'll do, I'll put you back in the waiting room and we'll give her some time to appear.
Okay, and then I tried to put in my last name when you came on. It allowed me to change my name, but
Don't worry about it. I'll let you do it on the record.
all right, thank you so much, Your Honor. But I am on this case,
I'll
so
put you back
thank
in the
you.
waiting room. Okay.
I'll go back to the waiting room. Thank you.
Yeah, that was for on another Davenport case. Apparently Marilyn Cone died recently.
Oh,
Yeah, she was in that. Okay, so what I'm going to do on your case, let's call your case and just do it on the records while we're here. This is file number 21162-535, Davenport University versus Kenya Fife. This matter is scheduled for hearing today at 11 o'clock on a debtor's examination. Could I have your appearance?
good morning, Your Honor. Najat Francis on behalf of plaintiff's attorney of record.
And your bar number is?
Oh, sorry, P72322, Your Honor.
And my understanding is, Ms. Francis, you were not able to serve the defendant?
That is correct, Your Honor. We did not get the subpoena back from the court to serve it.
Okay, well then we'll dismiss it. Look forward to your next one. Thank you.
Thank you, Your Honor.
Have a great day.
You too. Bye.
Bye-bye.
let's say Norcott was here in States. There was so. And he also penned 3 overtures. What he called the first was teenagers. Minutes after when people are calling, we did make our vote. Thank you, folks. 866-909-725. Our phone membership, it is our phone. No better way to celebrate this. And celebrate some yes. Today's yeah, back. That's our mission. Music. 14 hours. 14 hours classical music every day. 10 hours commercial free jazz, all with your partnership with us. Thank you very much. So, some people in this pledge and donate them. CR539. We've got 2 calls and clicks so far. So, 3 people have joined us. And from Brighton, good morning. Thank you for rewarding the from so it's my job to, but she's the first time. Thank you very much. As is Deborah. And it's made by you know, that it's everywhere. Well, guess what? So it's the one supposed to himself is there. We filmed him. Yes. And he is he's had cafes in the espresso. And you see him now, right? Right down. There's then he's talking to Alexa Bluetooth, which I believe is his right. So yeah. Let's be German. Let's see German, of course. And maybe even blushes. That you've decided to add the figurines to your collection. So how do you do it? It's more. Yeah, you do it. And make your pledge $3.30. $866-909-9725. My card most popular.
We are on the record calling file number 21-160595, Davenport University versus Aisha Harris. This matter is scheduled for debtor's examination today, October 26th at 11 o'clock. Could I have your appearance, please, counsel?
Certainly, Your Honor. Good morning. Sheila Siegel appearing on behalf of the plaintiff, Davenport University. for attorney of record, Marilyn Nyman Cohen, PLC.
What is your bar number, counsel?
Yes, P46184, Your Honor.
Okay, now you advised earlier that you had been able to achieve service of the summons on the defendant on September 17th.
Yes, I have been provided the file relative to this hearing, and I do have a proof of service. I believe it would have been filed with the court, although I can't say, I believe it would have been filed as is protocol. And that was on Saturday, September 17th at 10:06. I'm sorry, yeah, 10:06 a.m.
Okay, I do not have that subpoena in my file. Are
Okay.
you going to be taking over this file?
For right now, they're in transition.
Sure, I understand. So
because-
what I suggest would be as follows. First of all, what is the present amount of the indebtedness?
Certainly, Your Honor. It is $9,437.88.
All right.
Principal being just over $9,290 in interest has accrued.
Subject to receipt of proof of the subpoena on the defendant, the court will be willing to issue a bench warrant in this matter with bond on arrest of $9,500. You can send all that paperwork in and you can send it all in at one time, because at this point, we haven't caught up with your subpoena return yet.
Okay, I'm going to follow up with my office. I believe even in the recent past, and maybe before that even, the client didn't necessarily want to proceed with the bench warrants, but if I understand your direction is if we provide that, you will issue a bench warrant.
That's correct, counsel. So I
Okay.
look forward to your return. I've noted your pre-number in the file, and we'll figure out where we're going from here.
Thank you, Your Honor, and you have a wonderful day.
Sorry about Marilyn.
Yeah, thank you.
She was a nice person. I like her.
She was. Thank you, Your Honor.
Have a great day.
Bye-bye. You too. Bye-bye.